Hey, welcome to The Explainer. Today we're diving into something you don't often see in the movies. We're asking what really happens after that final dramatic verdict is read.
Right? You get that big courtroom scene, the jury files in, the foreman speaks, the gavel comes down, and then the credits roll. But in the real world, is that really the end of the story?
Oh, not even close. In fact, a lot of the time, that verdict is just the ticket to the next and maybe even more complicated part of the legal process, the world of appeals.
Okay, so here's our game plan. We'll start with why a verdict isn't always the end. Then we'll get into the specifics of criminal appeals and the idea of unsafe verdicts. After that, we'll see how things change in civil cases, tackle the whole messy business of evidence, and finally, wrap up with why an appeal is definitely not just a do-over. So first things first, what even is an appeal? It's really important to know that it's not a new trial. You're not calling all the same witnesses back to the stand. Think of it more like a crucial second look, a review process that asks one simple question. Was the original trial conducted fairly? And was the result a just one?
I think this is the best way to think about it. The appellate court? They're like the referees looking at the game tape after the game is over. They aren't there to replay the whole thing from the kickoff. They're looking for a serious mistake, right? A bad call by the judge that broke the rules of the game and might have actually changed the final outcome.
All right, let's start with criminal appeals. This is where the stakes are, as high as they get. We're talking about someone's actual liberty being on the line. And here, the big question the appellate court is asking is whether the conviction was safe.
And in this world, there's this really powerful legal idea, the unsafe or unsatisfactory verdict. What does that mean? Well, it means an appeals court can look at a conviction and say, you know what? A reasonable jury, if they were looking at this evidence correctly, really should have had enough doubt to acquit this person. It's not about what the appeal judges personally think, it's about what a proper, reasonable jury should have concluded.
And this quote really gets to the heart of it. The focus is all on the jury's process. Was their conclusion reasonable based on everything they saw and heard? Or did something go so sideways during the trial that the verdict itself it can't be trusted, it's just not safe? Okay, so let's say the court agrees. The verdict was unsafe. What happens then? Well, they've got a few tools in their toolbox. They could just acquit the person right then and there, case closed. They could order a brand new trial. Or, in some situations, they could substitute the verdict for a lesser charge if the evidence for that was undeniable. But, and this is a big but, there's something called the proviso. It's basically a reality check. Just because you find some tiny technical mistake doesn't mean you automatically win your appeal. If the court decides that, look, even with that mistake, there was no substantial miscarriage of justice, the outcome would have been the same, then the appeal can be dismissed.
Okay, so that's the criminal side. Now let's switch gears and look at the civil world. Cases about money, contracts, that sort of thing. And here the rules for an appeal get really interesting because it all depends on who made the original call, a judge or a jury.
And wow, what a difference it is. Trying to overturn a jury's verdict in a civil case, you have to prove it was, and this is the actual legal phrase, unreasonable and almost perverse. I mean, that's an incredibly high mountain to climb. But when you're appealing a decision made by a judge alone, the appeal court gives deference to that judge. Why the different treatment? Well, it's all about what the judge gets to see that an appeals court never can.
And this description just captures it perfectly. The trial judge is there for the whole thing. They see the witness's demeanor, their body language, the pauses. They're soaking up what's called the human atmosphere of the trial, something you will just never, ever get from reading a cold, printed transcript. So this whole idea of deference isn't just about a gut feeling. It's super practical. It recognizes that the judge was actually there, seeing and hearing the witnesses. They're experts at fact-finding. Plus, it prevents endless, costly do-overs. The system is designed to make the trial the main event, not just, a try-it on the road for the real show in the appeal court.
All right, this brings us to what is often the most dramatic part of any appeal, evidence. What do you do when brand new, game-changing evidence pops up after the trial is over? And what about when a mistake was made with evidence during the trial itself?
So you can't just walk into an appeal with some new document and expect a do-over. The bar for introducing fresh evidence is incredibly high. You have to clear all three of these hurdles. The new evidence has to be believable. It has to be so important that it probably would have changed the entire verdict, and
This is the real kicker. You have to prove there was no way you could have found it before the first trial, even if you were being reasonably diligent.
So, to put it simply, you basically need a smoking gun that was completely hidden until now. You can't strategically hold a card back to play it later if you lose. And this rule is tough for one major reason: to ensure that trials have a sense of finality.
Okay, but what if the mistake wasn't about new evidence, but about how the old evidence was handled? Let's say the judge made a bad call and let in some testimony they shouldn't have, or kept out a document that was crucial. If that error was serious enough that it could have swayed the final decision, well, that can absolutely be grounds for a new trial. Because at the end of the day, every party has a fundamental right to have their case played by the proper rules.
So after all of this, when you step back and look at the whole picture, it becomes pretty obvious that the appeals process is not just a mulligan or a second chance. It's a really specific, carefully designed system with a very clear purpose. And this chart breaks it down perfectly. The appeal system is a meticulous review, a check for serious legal errors, and a crucial safeguard against miscarriages of justice. What it is not is a simple do-over, a complete replay of the case, or an easy way to reverse a loss just because you didn't like the outcome. The whole thing is a constant balancing act between finality and fairness. And that really leaves us with the big question to chew on, doesn't it? This whole system, with its super high standards, its deference to judges, its strict rules on evidence, is this complex, cautious machine. It's designed to make sure that justice isn't just done, but is seen to be done correctly. So the question is, does it always strike that perfect balance? That's something worth thinking about. Thanks for joining us on The Explainer.